At 3 o'clock in the morning, Colombian time, the verdict of the litigation between our country and Nicaragua was issued. This against the claims filed by the Central American country for alleged violations of sovereign rights in the Caribbean Sea committed by Colombia.
Court in the reading of the ruling stated that Colombia's conduct was not in line with the international law, and this violated Nicaragua's rights in its exclusive economic and maritime zone when it was carrying out exercises to control and conserve natural resources in the sea.
The court finds that Colombia has violated its international obligation to respect Nicaragua's sovereign rights and jurisdiction in the latter's exclusive economic zone by interfering with fishing activities.
The court also concluded that Colombia must respect Nicaragua's sovereignty and, in accordance with international law, must remedy the violation as it occurred.
The court finds that Colombia must immediately cease its wrongful conduct.
This is due to the fact that the ancestral rights over the disputed territory has not been proved.
The court is mindful that traditional fishing practices alleged to have taken place over many decades may not have been documented in any formal or official record. The court is of the view that the affidavits submitted by Colombia do not sufficiently establish its claim that the inhabitants of the San Andres archipelago, in particular the Raizales, have been engaged in a long-standing practice of artisanal fishing in traditional fishing banks.
During the reading of the ruling, the court recognized the rights of the Raizal people to navigate and fish in Nicaragua's exclusive economic zone. It is also pointed out that the Nicaraguan state has the will not to negotiate the zones with Colombia.
May freely navigate within Nicaragua's exclusive economic zone, including in the course of their travel between the inhabited islands and the fishing areas located on Colombia's side of the maritime boundary.
In this way, the court asked the republics in dispute to negotiate bilaterally between the two parties.
And after the judgment of the International Court of Justice was known, the President of the Republic, Iván Duque, speak on the regard from the island of San Andres.
The International Court of Justice in The Hague issued its ruling today in relation to the lawsuit filed by the country of Nicaragua in 2013, where it denounced alleged violations of sovereign rights and maritime spaces in the Caribbean Sea by Colombia. The court indicated that our country violated Nicaragua's rights and several international articles. It also requested a bilateral negotiation between the two countries. Regarding the situation, the president made a statement.
Today's rulings defends aspects of great importance that validate our defense. In the first place, the National Navy will be able to continue to be present and exercise its right to free navigation and overflight in the air. The court recognized Colombia's right to navigate freely in the area to fight transnational crime and drug trafficking. From the beginning, this was the position of Colombia's defense, and it was what the court ratified today. Secondly, the unity, integrity, and indivisibility of the archipelago of San Andres, Old Providence, and Santa Catalina and the Keys are maintained. Thirdly, the Raizal fishermen can navigate in the Caribbean until they reach the fishing banks that they have and have had historically, and that are also in the Colombian territorial sea and in the exclusive economic zone of our country. The national government ratifies the constitutional mandate to defend the sovereignty and integrity of the island and the rights of our nation.
The president indicated that the national government since 2012 has tried to seek through dialogue to solve the problems with the country of Nicaragua, but the Central American country closed dialogue in 2014. Likewise, the president referred to the Nicaraguan government as a dictatorship that through its actions draws the attention of other democratic countries.
The departmental governor also reacts on the decision of The Hague.
Governor Everett Harkin's chagrin shares his first observations on the decision given by the International Court of Justice at The Hague, in which he highlights the oral participation of the Raizal team as an essential basis in the defense and promises to deliver favorable results in an upcoming meeting before the ICJ.
Despite the fact that the court did not consider with sufficient weight the proof of the ancestral practice of the Raizal people, it is said it cannot ignore it. But it did convince the two states to sit down and seek a treaty that guarantees their rights. But the important thing here is that the court recognized for the first time in the history of the Raizal people, which had not been the case before, It also says that it is possible to navigate in the exclusive economic zone of Nicaragua.
He also stresses the importance of the birth of a treaty between the two nations.
But as the president says, the Constitution does not allow the modification of the limits. Hopefully, from here, the need for a commission to begin to make these approaches and seek a treaty that guarantees the ancestrality of both countries is born.
The Rizal team stands on the International Court of Justice decision was clear and constant. Joseph Jesse and Ken Francis, the two Rizals who were present as this process, agree that this is a historic day, as the indigenous Rizal people of the archipelago of San Andres, Old Providence, and Santa Catalina are recognized in the court's ruling.
The position on the court ruling revolves around the recognition of the rights of the Rizal people in the disputed territory. Ken Francis highlights that it is clear that the court pointed out that Colombia has violated the sovereign rights of Nicaragua. However, it was admitted that it is necessary to reach bilateral agreements to establish the borders.
What we have to do now is to work rapidly on this idea of a treaty and begin to put it in force.
The Rizal leader also emphasized what for him is a historic event for the people, and that is the recognition of the Rizal people before the International Court of Justice.
We are a people now that can call upon the international authority for our rights to be respected and our environment to be protected. The right of living in an area, it means that we must live in an area in peace.
For the Rizal team member, it is a stronghold that the Rizal people have been visible before the court since its intervention last year. For his part, Joseph Jesse, who was present during the reading of the judgment, said the following.
Three things very important. One is that the court finally recognized our existence, our presence in the area. That was something that we were working for years. Finally get that. Second, the court recognized our right for fishing in and transit in the area that is in dispute between Nicaragua and Colombia. And thirdly, the court present before the two parties that they are supposed to make some type of measurement in regards of the protection and the recognition of the rights of people in the area. So diplomacy come to be part of a fundamental part now. So we as people can talk to our fellow partners from Nicaragua to see how both nations find measurement in the protection of our existence in the area and to establish the rights and also the type of obligation that we have in matter of transit and fishing. But mission accomplished. The Rizal people can say today that we have something, and something strong that we can continue striving for the future.
According to Jesse, in this case, Colombia, particularly the Rizal people, will be able to agree with Nicaragua on the measures or agreements that both countries can reach for the protection of the Rizal people and the natural maritime resources, as well as the limits of transit, navigation, and fishing in the disputed territory.
Representative to the House Elizabeth J. Pan gave a statement on her perception of this new ruling from The Hague.
For the parliamentarian, it was of vital importance to maintain and create dialogue with the Central American country of Nicaragua.
Bueno, si bien es cierto que quisiéramos.
While it is true that we would like to recover the 75,500 square kilometers of maritime territory that we lost, it was also true that we had diagnosed that they would ratify the 2012 ruling. But there is an important aspect, and is that there is gain in that they have recognized all the ancestral rights and the protection of the environment, which is the life of the archipelago, which makes us different. But it is also true that we need to establish friendly dialogues on border limits with our Nicaraguan neighbors with the aim of developing our ancestral fishing economy. We need conservation. that we all speak the same language, and that we create sustainable development for our biosphere reserve. That is why I will continue to insist with the national government on these dialogues with Nicaragua to look at the border limits and how we are going to do if a fisherman goes a few miles over into Nicaragua's territory, or if Nicaragua does the same inside Colombia.
Teleislas News was also in contact with the representative Jorge Mendez, knowing his perception. However, until the closing of this broadcast, it was not possible to get an interview. This news team will be attentive to his future declarations.
And this news agency connects at this time with a lawyer who, from his legal perspective, provides us with an analysis of the summary of the ruling of the International Court of Justice.
Nicaragua
presented 50 motions, of which only 16 were accepted. First, Nicaragua's claim that Colombia did not accept the 2012 ruling. Second, all land in the 82nd Meridian South, Southwest Key, Quitasueño, Roncador, Serranía, and Bajo Nuevo are under Colombian sovereignty. Third, they stated that Colombia and Nicaragua will maintain their jurisdictions as long as a treaty is not approved that modifies the limits of the parties. Fourth, Colombia will be able to continue its presence in the Caribbean Sea since Colombia is not using force. Colombia mentions that the movements in the area are clearly aimed at drug trafficking, and it seems that it has not been able to demonstrate this. Fifth, Nicaragua requested that Colombia pay for the damages suffered. However, in line with the previous point, this was not demonstrated, so it was not granted. Sixth, which is what interests us most with respect to the Raizal population, The Hague requested that Nicaragua not impede.
Jason Taylor, island lawyer, gave his point of view on the decisions taken by the International Court of Justice.
Teleislas News managed to obtain statements from lawyer Jason Taylor, who analyzes the decisions taken by the International Court of Justice at The Hague, affirming that it could be said that this decision favors Colombia since the court does not recognize compensation to Nicaragua. This would be one of his arguments.
Desde mi opinión personal, pues yo pienso que
From my personal opinion, I think that when we review the two claims of Nicaragua was to establish the baselines and compensation, and that the court does not grant it. From there, we can say that it is favorable, obviously without having to talk about that there is already a ruling that affects us directly in 2012. But developed in this, we see that these two claims were not acquired, and with that, we can already say that it is favorable for Colombia.
Within the paragraphs, according to its analysis, the court recognizes the Raizal people, but not their ancestry.
reconoce que hay un pueblo, un asentamiento raizal.
Recognizes that there is a settlement of the Raizal people that was not seen in the previous ruling, which means that it is an opportunity to support the contempt and the Colombian government is making. Therefore, the court is very special in that it recognizes the Raizal people but not the ancestry within the entire margin or those strategic geographic points of the sea that they speak of. It is not enough evidentiary material to give them an ancestral status.
One of the court's requests is for Colombia to enter into bilateral agreements with Nicaragua. In this regard, Taylor states,
Colombia y su constitución solamente permite
Colombia and its constitution are only allowed to modify, as I have always said, its border by means of those agreements endorsed by the Congress and signed by the President. It means that this is the right way out, but we have to keep in mind that this contempt is protected in its defense of the ancestral rights.
Finally, this islander highlights the importance of the court recognizing the Raizal population, which can exercise their fishing activities.
Hoy día se reconoce.
The important thing, or the most important thing, is that today it is recognized that there is a Raizal population that practices fishing as an activity to sustain its economy and survival in the territory.
Regarding the decision and the implications of the court ruling, we also consulted the perspective of Silvia Mantilla, a philosophy doctor in international relations.
Silvia Mantilla, PhD, Doctor in International Relations, Professor and Researcher at the University of Columbia with expertise in border issues, international security policy, Latin American and Caribbean studies, also shared her analysis regarding Colombia's defense, the implications for the Rizal people, and particularly for fisher folk, and how Colombia should act in accordance with the ICJ ruling.
En cuanto a las decisiones.
Regarding the decisions and implications in relation to the fishing rights of the Rizal community in these maritime areas, the outcome has been unfavorable for Colombia. In this regard, the International Court of Justice determined that Colombia has the burden of proving that the Rizal have historically practiced artisanal fishing in the current exclusive economic zone of Nicaragua. So we can infer that Colombia failed once again to gather sufficient historical evidence to defend this assumption of ancestral fishing as a customary right. The International Court of Justice continues to grant Nicaragua the right to determine a permissive catch of living resources in its exclusive economic zone solely and only when Nicaragua does not have the capacity to catch the totality of the resources and can give access to this surplus catch to other states, but always through a signed agreement between the countries. If Colombia wants to regularize the fishing activity of the Rizal fishermen in this zone, it cannot continue to ignore its state responsibility in any way and must first and foremost respect the rights of Nicaragua in its exclusive economic zone and seek an agreement with its neighboring country.
Mantilla emphasized that in effect the bilateral agreement is the best scenario for the countries.
Entonces, a partir de la decisión de la Corte.
So from the decision of the International Court of Justice on fishing rights, we can infer that for the Rizal people, for the moment there would not be an effect in the sense that they can continue to move freely through this zone. However, there is a clear manifestation of a negative impact in relation to the legal possibilities that these fishermen have to develop their economic activity and traditional fishing. Unfortunately, the fishermen have been left in a legal limbo in this situation and are negatively impacted by the ruling. They are the ones whose rights are somehow being ignored or subordinated to the need for the Colombian government, which has been very reluctant and opposed to the search for a treaty or an agreement that could guarantee and benefit the fishermen of the area. In effect, the bilateral agreement is the best scenario under the acceptance of the decisions of the institutions and the international regime of the International Court of Justice and the recognition of the rights of the neighboring country of Nicaragua.
And the director of the Coralina Environmental Corporation provided an analysis of the decision of the court and answered the question of whether this ruling affects the seafloor biosphere reserve.
El fallo de la Corte Internacional de...
The ruling of the International Court of Justice in The Hague is not oppressive. Simply what it does is ratify a decision made in 2012 and some bonus. And what is that bonus? That once the ruling came out in 2012, what our country did was to change the strategy and involve our Rizal wise men who did a great job, and there they included a story to reach an agreement. So for me, the decision of the International Court of Justice is simply to ratify a ruling and say to Colombia, there is a ruling. Comply with it, but sit down and agree on fishing activities within the framework of the exclusive economic zone where the artisanal fishermen play an important role. I would dare to say that it is necessary to sit down and talk technically to see how we can protect this great Caribbean and make it a transboundary reserve in such a way that we protect everything and that we do not depend on a diplomatic agreement but on something technical.
Coralina's protector of the Biosphere Reserve clarifies whether or not the ruling affects this protected area declared by UNESCO in 2000.
No afectó, sigue, o sea, de los...
It did not affect the 185,500 square kilometers that we had jurisdiction within the Biosphere Reserve, and we must take into account that 65 square kilometers is a maritime area protected by the Corporation and the Maritime Areas of the International Court Justice ruling for Nicaragua do not affect the preservation zone of our marine protected area. There are some accesses to get there that have to pass through Nicaraguan water, but that is where the agreement between the two countries must be established.
In Teleislas news, the community counts, and these are their reactions to the decision taken by the International Court of Justice in The Hague.
Fishermen on several occasions have referred that they have been the most affected since the 2012 ruling where Colombia lost much of the territorial sea. They have said that they do not feel safe when leaving to go fishing. When consulted today after the new decision of the ruling of the International Court of Justice in The Hague, they say it would be good and important to have bilateral agreements between the two nations.
We are brothers and sisters with Nicaragua because we must remember olden days Nicaragua used to bring all his product here and sell. We buy and we was one family. But just through this thing come out now, we turn enemy. But up to now, we don't have nothing against Nicaragua.
Well, I think we should make a good treatment with Nicaragua about our fishermen from San Andres and the one them from Nicaragua, that we can go down there and fishing, and then can come both up there and fishing. And we don't have any problem because I think we talk the same language and we should be united till to the day. And we're not supposed to have no problem because we always neighbor and we're not supposed to have any big problem.
Well, you're all right because San Andres people and Nicaraguan people, we all the time unite. But when it comes to government, them got them problem all the time. But really what happened with the water, it won't be one combustible for you because you're going to go fishing with pressure on your back. Too much pressure because, you know, anything can happen if you're in the midst, anything can go on. That's the way we never want. You don't want to go and you don't have afraid because really and truly place for and then they give away the water and we have to live with what the Colombian government say. But if they share the water, we have to look and see how you want to share because there's too much pressure. We never know what can happen between the two countries and the fishermen who they feel all the strain.
We never having problem with Nicaragua. From I was a little boy coming up, my family used to go down to Nicaragua. They have picnic and things. They come out here. They have baseball, and we share with them. But lately, I don't know what is the problem with them and Colombia, and we suffering the consequence because that they're not suffering, we suffering. Our fishermen. We used to go down there and we carry things down there. We have excursion, they come up here and they have flat pool, and we used to have it very nice. But lately, I don't know what is the problem. That is between the big fishes then. But we, as an islanders, we have no problem with Nicaragua. Nicaragua tell we can go down there and fishing, and we can go down there, we have no problem. But he say don't want, I think the big fishes, them trespass down there because them make the problem, and they got to stand to the problem. We don't business with the problem where we islanders people.
For the fishermen, this conflict has completely affected their economy development. That is why they are waiting for agreements that will make them better off.
There is no fish in here. The fish is in Nicaragua's zone. Since Nicaragua took over the sea, we are doomed. There we had to fish with the engine running. So when we see the Coast Guard, we had to push the engine up to the limit.
And now we continue with the reactions to the judgment of the International Court of Justice in the municipality of Old Providence and Santa Catalina.
The Old Providence community also shared their perception on the decision taken by the International Court of Justice early this morning.
It's very important to
to say this a little bit more profound. You just can't just listen to what them telling you through the news, because we have to analyze each point. But my recommendation is, like, the two countries should sit down and talk about what treat and how to see how we can benefit the communities that, like, ancestrally are here in these islands, not just in Providence, San Andres and Catalina, also in Nicaragua and other places from Central America, you know, and from the small island them.
You know, the people them really don't understand what took place, because it's a confusion. It's almost the same thing. Fishermen going to go out there, and this one will harass them. The same thing will happen. Two countries have to come together and talk, and more and all, how I see this thing, it's not the central government supposed to take decision on this. What I think is the coast, the Mosquito Coast and we islanders, Providence and San Andres, come together.
On the other hand, some have taken a more radical position, saying that none of these countries should be fighting over the Rizal territory.
In June of this year, we are going to celebrate 200 years of annexation, 200 years of losses. They have mismanaged our interests. They have made mistakes for us. Now we have the right to make our own mistakes, and we have to start a process of independence from a country that has been very badly grateful to us and that has administered our interests too badly.
For now, Providence natives will continue to wait on their participation in the bilateral agreements on the fishing rights of artisanal fishermen suggested by the